Jacques is the head of the Belgian Competition Authority, the chair of the Belgian Competition Authority. So without waiting too long, I am inviting Mr. Jacques Steenbergen, please. Thank you.
Good afternoon. May I also first thank most sincerely, most warmly, the organizers for the splendid way this conference is organized, and all you for being so interested in competition and competition law. Not all conferences attract such a wide audience. Now, you may say that interim relief cases are not really within the ambit of the contemporary new issues. It depends. Of course, in courts, we've seen interim relief cases, interim measures cases, injunction cases, procédure de référé, whatever you call them. And what we see in a number of jurisdictions, also in mine, is that for many years, that has really, they have been used in courts, in civil law cases or commercial law cases. May I ask whether any of you has been involved in an interim measures injunction case? Yeah, and related to competition? No. Now, what we see, is that you see them mostly, if not until now exclusively, with regard to abuse cases, abuse of dominance, unilateral conduct. And that is logical. But they can also be used in other frameworks. Now let's first try to see why they should not only be used in court by lawyers bringing a case to an ordinary court, but why it might also be an idea to bring them to a competition authority, and why competition authorities should look into them. And with regard to the competition authorities, it's a topic with a different history, a difficult history. It's one of the few areas where the European Commission initially said that it had no powers, and the court had to decide that it had the power. Usually it's the other way around. And I refer to the Camera Care case of 1980, so that's an old case. It's then in the present regulation, 1/2003, that the legislator explicitly stated that the Commission has the power to grant interim relief. But it has hardly ever been used, and not at all in recent history. That's different in some of the national authorities. That's probably why they asked the national authority. My French colleagues are very active with regard to interim relief. We are active, and others are interested. And it's only last week that we had, I think, for the first time, a more focused debate among the heads of authority in a meeting in Brussels on the issue of interim relief and how we should assess it and what we could do with it and what we may have to do when we do it. So from the competition authorities world, it is a recent development. Now for the parties, what can they hope from it? Well, first, in these abuse cases, and why are they brought in a number of our jurisdictions regularly to the courts? They can avoid the damage. And that, as we say with regard to medicine, it's always better to avoid than to cure. You can obtain an injunction to stop what is potentially an abuse. It is also a way of what you could call testing the waters. And we've seen that recently. Bringing a case to see whether the authority will decide that there is a prima facie case. And if there's a strong prima facie case, it might be a good idea to settle it before the competition authority reaches an end conclusion. For the authorities, it has the significant advantage that it brings forward the useful effect of infringement cases. Whatever we do, however fast and efficient we try to be, stakeholders will always consider that our decisions take too much time and come too late. Now, one of the previous speakers has given a few examples where it really takes a lot of time, but it will always be too late in the opinion of most. If we really want to take due process seriously, investigate properly, I think between 2 and 3 years is about as fast as you can expect it to be. And that, we hear regularly, is much too late. If you have an interim relief case, there is a signal that comes earlier. That is good for the parties, it's good for our legitimacy. It is, and it's the mirror image of testing the waters, it is also a good opportunity for us to signal that it might be useful to seek a settlement. It might be prudent. And then we have a tricky issue. As competition authorities, we like competition. But we also like to keep our market share, like all good competitors. And if the interim measures are only granted by the courts, it is the courts who will also decide on the main cases in most jurisdictions, and it is the courts who will develop the competition policy. Now, that as such is not necessarily a bad thing, but it would at least be helpful if we had some input by having a case law they can refer to. So interim relief facilitates our ability to develop case law, not only in the interim relief decisions itself, but if we grant the interim relief, the main case will also stay with us. Who can seek them? Well, that depends, of course, obviously a little bit to the domestic law of the different jurisdictions. The main problem is that you need somebody who is aware of the problem to seek interim relief. And that is why you will always see them more in abuse cases, because most people do know that they are abused, but most people cannot be expected to know that they might be the victim of a, by hypothesis, secret cartel. Private parties always have the choice between competition authority and the judge. And it is for us, the competition authorities, to prove that we are a worthwhile alternative. Worthwhile in our own interest, as I decided before. The competition authority can seek interim reliefs in many jurisdictions, in ours as well. It may sometimes be useful in an ongoing cartel case to make it stop, but frankly, that will, I think, always be extremely exceptional, because when you, in the course of an investigation of a cartel, require people to stop, they usually do anyway. More important is that when there's an interim relief procedure, and that is not possible everywhere, as I understand, it is important that the competition authority is not bound by the relief that is sought by the parties, but that it can modify the measures that are asked for in order to take into account not just the private interests of the people who bring the case, but also the public interest we have to take into account. The institutional landscape. One of the areas where the competition authorities in the European Competition Network are working on is to get a better view of the institutional landscape. Because the differences between our jurisdictions are much more important with regard to interim relief procedures than with any other kind of procedure that is relevant to competition authorities, except, of course, the ability or inability to impose criminal sanctions. Can there be parallel enforcement? Has anybody exclusive powers? But then very important, what is the weight of prima facie argument compared to the risk of damage and the need for causality? May I ask you, and then especially the Turkish experts in the room, in Turkish interim relief procedures, injunction procedures, référés, is the emphasis on the legal issue or on the avoidance of damage? Who says on the legal issue? Who says on the avoidance of damage? It cannot. Who says equally on both? This is interesting. Do you have interim relief? Yeah, you have, because some have been involved. Yes, please.
Measures, and you need to show serious and irreparable harm, much like the European system. My humble view is that the legal case takes precedence over the seriousness of harm. So if you don't have a prima facie case, the judges would be intimidated and they wouldn't want to grant an interim relief. But in instances where you have a prima facie case so obvious, where the potential for damage is so extremely low, you still may not get your interim relief. But without the prima facie case, you can forget about it. So I think that's the balance in Turkish law.
Thank you for helping to make it interactive also. Now, in our case, like in many of the more Latin jurisdictions, the threshold for prima facie is very low. You must have it. If you don't have it, end of the case. But the standard is, would it be unreasonable, manifestly unreasonable, to think that there might be an infringement? That's not a very tough test. But in the Netherlands, in Germany as far as I know, and in some other jurisdictions, you almost have to make the legal argument not as in a main case, but almost as in a main case. With us, the emphasis is purely that you have to demonstrate that there is a risk of damage that cannot otherwise be avoided, and that the measure is proportional to the risk of the damage. The legislator, explicitly, and not at the request of the competition authority, lowered the standard there as well. And the same has happened recently in the United Kingdom. We moved from irreparable to difficult to repair. And the UK did something similar, but both in the UK and with us, we can't say that it has already made a significant difference in practice. We tended to be already close to difficult to repair, because what is impossible in this world? When there is a focus on the legal assessment, the risk of, in the short term, that policy is really set by the courts is higher than when the emphasis is on avoiding damage. Because if the court basically has to almost to decide the case in law, that's where the policy mostly is, more usually than in the assessment of facts. The case is to a large extent decided. In the longer term anyway, because the main case stays with the court in most jurisdictions when the interim relief was with the court. And I cannot see many competition authorities that would decide on a case that is also pending in court, even when parallel jurisdiction is not excluded. Also, in the institutional landscape, the damage. What do you really try to avoid? Do you try to avoid damage in the ordinary sense as in a tort case? Or do you primarily try to protect the useful effect of the final decision? In our case, it is both. But one of the two, it can be both. It doesn't need to be both. Interim relief and main case. A difference between the jurisdictions is whether there must be a main case. In our case, and as with the European Commission, the legislator also in the last reform insisted that only interim relief when there is a request for a main case, and the main case must follow the interim relief decision. There are jurisdictions where there's never basically an main case decision after the interim relief has been granted or refused. An issue I'm sure that will be discussed within the network of competition authorities is the question, if you have a main case after the interim relief, will it be the same team, the same decision makers? In France, it is excluded that it would be the same decision makers. Totally unacceptable. In Brussels, the other Brussels, European Union, and in Luxembourg, it is the same team. In other national jurisdictions, it may differ. And the last point I would like to mention with regard to the institutional landscape and the challenges we meet now that we're discussing interim relief more within the network and from a competition law and policy perspective is the attitude to prejudging. Now here there's a clear parallelism with which we discussed before. In jurisdictions where the test for prima facie is a difficult one, they're not so worried about prejudging, otherwise you cannot meet that test. In jurisdictions where the test for prima facie is a low one, you're usually very worried about prejudging, and you should really avoid, in your interim relief decision, anything that might be too binding or might prejudge, and especially if the same team will decide the main case, the decision at the end, and that obviously in the interest of the rights of the defendants. With regard to the measures that can be taken, we already discussed the issue of bound by the petitum. A more tricky issue is the issue of the duration, but then particularly in what is mentioned on the slide, whether in interim relief you can only take a decision after a contradictory procedure or also on unilateral request. Now, in a very distant past, when I was legal secretary to the president of the court in Luxembourg, the president repeatedly took interim relief decisions unilaterally without hearing anybody. And he took them usually within 24 or 36 hours. And then there was a new phase in the same interim relief procedures, contradictory, after hearing the parties. Now, if you really want to avoid damage, it is sometimes very important that you can act immediately. For instance, to stop some construction works, or could give you other examples. We cannot do it under Belgian law. There's only the contradictory procedure, which makes that it takes about 2 months, 1 to 2 months. That's still long, I think, for interim relief procedures. Again, in the 80s, when I was at the court, the average duration of a contradictory procedure was 11 days. If you brought a court on Tuesday, the commission, it's always the commission, the defendant, the commission had to file its defense on Friday noon at the latest, hearing on Tuesday, decision on Thursday. That was the normal procedure. Now, if you look at the case law of the court in recent years, it's no longer like that. And sometimes I wonder why, because cases have probably become more complicated. But they were not always easy at that time, but when they were very difficult at that time, it could also take longer. The average was not necessarily defined by difficult cases. So if you want to promote a system, I would advise you to include the possibility of unilateral action, always followed by a contradictory one. But I have not succeeded in getting it in our system. Enforcement of interim relief. I think the systems I know that have it usually have a system of penalty payments. Now, those for the institutional aspects of those points for the institutional aspects of taking a decision, enforcing a decision. But quite often, measures that have been defined under time pressure are not always equally clear, and it's not always equally clear how to implement them. It is therefore also important that the decision that imposes measures, at least that is our experience, defines a procedure to modify, if necessary, and certainly to interpret. And that is something which has worked well, I think, in the jurisdictions that have it. What I would also very much advise you to do if you want to introduce rules on this, or when you're taking decisions, because you can also do it on a decision-by-decision basis, is to have a sunset clause. The sun rises very early in this beautiful city. It also sets rather early, but it is very important that you have something similar in interim measures decisions. A part of the decision that says, or a rule that imposes, that the duration of the interim measure is defined and that they lapse afterwards. What we have found, and one case is pending before our authority right now, and there is a hearing today, another one. It's an interim relief, it's an not the following the consequence of an interim relief decision, but a remedy in a merger case. And you can have exactly the same in interim relief procedures. The remedy was imposed in 1997. Every time the authority wanted to end and not renew the measure, there was a complainant who complained against the non-renewal, went to court, and the court annulled the decision. This is bad enough in merger cases. We should not repeat something similar in interim measures cases. Also, with regard to judicial review, it is important, obviously, that there is judicial review, but it's very helpful if it is not suspensive. And that if one wants to ask for a suspension, that should be asked to the court. It should not be automatic. This is what I wanted to tell you briefly on our experiences and on what we're working on with regard to interim relief procedures in competition cases for competition authorities in general. Now, I have a few more points that are specific to the EU and which are now also specifically discussed among the heads of authority, and an ad hoc working group has been set up. As you heard before, there is criticism of the fact that decisions can occasionally divergent. Now, as it was also said, before. I think one should not exaggerate this. Both in merger control and in other cases, the number of really divergent decisions compared to the number of files that have been dealt with is minimal. But every single one is one too many. I will not deny that. But what we see with regard to interim relief is that there is no convergent mechanism at all. We do not have to send draft decisions to the Commission. And in any case, if the Commission would then have the normal deadline to review them, I don't think the urgency test could still be passed. So it's not easy to have the same kind of convergence procedures. But we do not even have, even though we usually do, we do not even have an obligation to indicate to our colleagues that we have received a request and open a procedure. So there we will absolutely see developments in the coming months or at the latest next year, and we're actively working on an early warning system, and that with regard to tricky issues, some call them novel issues, because the criticism we've heard with regard to booking.com, etc., we may not always agree with it, but that doesn't mean that we're not listening. And reducing risk is always better, even when the problems are very few and in between. More difficult is the issue of what if the Commission takes a case when a national authority has already taken interim measures. I would not be surprised, and it has already been said by my colleague of the European Commission, that the attitude within the network to 11.6 measures, decisions, that means the Commission taking a case that has already been opened by a national authority would become a more common tool instead of a kind of taboo. I mean, it was referred to until recently within the network as the nuclear option. If the Commission did that, that was the ultimate insult. Frankly, be convinced that that is not the way the meetings of the head of authority still thinks about it. We perfectly realize that it may be in our own interest, and sometimes we may even ask for it. But what if we have already taken interim measures? Because the Commission has indicated that even though they have an open mind, they do not really intend to open the door too wide. So are we then going to lose all the useful effect of interim measures when we want to deal with a convergent mechanism on new issues? The line of thought we are now working on is that when the Commission takes the case, but there have already been interim measures, the interim measures would stay in place. There are serious legal obstacles, also in my opinion, for the national authorities still to be able to take interim measures when the Commission has already opened the case. I agree with the legal service of the Commission that that is very difficult to reconcile with the text of Regulation 1/2003. But the fate of interim measures that have already been taken, that is in the gray zone, and there we may be creative. So here I have discussed with you, as open as I would do it anywhere else within the Union, the issues which are at present being studied and examined, and all creative solutions coming from whatever side of the world are very welcome. Thank you.